Happy holidays and welcome back to another J. Harris Academy of Police Training Roll Call. Today we're going to be discussing DWI stops. This is State of New Jersey versus Jeffrey Morton. It's an appellate unpublished decision on December 23rd, 2024. And this ruling relied heavily on State versus Kevin Boone. Kevin Boone was an appellate division published opinion decided July 24th, 2024. For more information on that case, we did a video on that on July 27th, 2024. It's posted to our YouTube as well as our Teachable as a free download, as are all of these roll calls. So for this case, shortly after midnight on May 30th, 2021, the defendant was driving in the rain on Route 9 in Freehold Township. Officers on patrol when they noticed a Chevy Silverado driven by the defendant starting to list over to the left over the solid yellow line in the left lane. Officer pulled directly behind the defendant and observed him again drive over the solid yellow line. The defendant crossed the yellow line 3 more times over the next 20 seconds and almost hit the grass median. The officer activated his lights and conducted a motor vehicle stop. After the defendant stopped, 2 officers approached the vehicle. The officers identified themselves. They asked him for his license, registration, insurance. And after he provided those requested documents, his movements were a little slow. While the officer was speaking to the defendant, the officer smelled an odor of alcohol emanating from the vehicle and on the defendant's breath. He then asked the defendant to step out of the car to do field sobriety tests. During the field sobriety test, the defendant failed to touch his heel to his toe while attempting to perform the walk and turn test, failed to keep his balance while performing the one-leg test, and failed to recite a segment of the alphabet as instructed. The mobile video recording captured both the defendant's driving before the stop and the field sobriety test. The defendant was arrested and transported to headquarters. While en route, officers continued to smell an odor of alcohol coming from the rear passenger seat where the defendant was sitting. Once at the police station and while the defendant was being processed, the officers continued to smell the odor of alcohol on the defendant. An alcohol test was administered. However, they were not admitted to trial due to an officer using a cell phone outside of the room, so those results were suppressed. The defendant now appeals his conviction, arguing that the stop was not valid under State v. Boone, and the officers did not comply with the scoring protocols for administering the standardized field sobriety test. The defendant argues that under State v. Boone, a police officer must include particularized credible details to justify an initial motor vehicle stop, and factors such as driving conditions, the size of the vehicle, the number of times the vehicle travels outside the lane, and the amount of time the vehicle continued outside of the lane must be considered. The defendant argued that the officers failed to meet these criteria, and therefore the law division should have granted his suppression motion. Officers noticed the defendant starting to list over to the left over the solid yellow line in the left lane of Route 9. After pulling behind him, the defendant drove his vehicle over the yellow line of the left lane. This occurred 3 more times over a short amount of time. The car almost hit the grass median. Both trial judges found the officer's testimony credible, and his testimony, combined with MVR footage, corroborated his observation that the defendant violated 39-488, which is failure to maintain lane. Although the officer was not well versed in the scoring factors, both the municipal court and the law division found the officer's observational testimony credible. Additionally, both courts cited specific facts in the record to support their findings. Both courts reached their probable cause findings based on the totality of the evidence in the record. Neither court found the officer's lack of experience scoring the field sobriety test hurt his overall credibility, and our jurisprudence calls for deference when, as here, 2 separate courts have examined the facts and reached the same conclusion. The appeal is denied. Though the appeal was denied in this case, there's a couple of key takeaways and ways that we can improve for the future. Number 1, standardized field sobriety tests are standardized. We should be giving them exactly as prescribed on the form. You should be reading it the same way we recommend that you read Miranda rights. You should be looking for the specific articulable points that make somebody actually fail one of these tests. That is the best practice. If you deviate from the standardized test, it is very likely that it will be challenged in court. Not necessarily that you'll lose, because everything's based on the totality of the circumstances, as they say in this case. However, it is much easier for us to get a conviction when we stick to the standardized tests. Beyond that, let's talk about Kevin Boone. Kevin Boone, he All the detective did in that pretextual motor vehicle stop is say that he crossed over the double yellow line. He made it very clear in that case that he crossed over the double yellow line, and he felt that that was enough for the RAS of the violation of failure to maintain lane. Compare that general statement of crossing over the double yellow line to what we see in this case. That was very well articulated. He crossed over the double yellow line. He then crossed over the line again. He then crossed over the line 3 more times within 20 seconds. One point, he nearly hit a grass median. You're painting a picture and articulating a picture here that makes it clear that we have to stop this vehicle. Look at it through the lens of community caretaking or emergency aid doctrine. We're not going to wait for him to crash. The idea of these stops for DWIs is to prevent fatalities, to prevent people from getting hurt in crashes. When you paint that picture and you show that this person driving was a risk to public safety, it's very likely that the judges will rule in our favor. Additionally, I just want to bring up a point that I always beat home in our classes. You are always going to be judged on your experiences, your training. No one expects a 1-year rookie officer to have the same experience as a 15 veteran officer. We are judged on what's objectively reasonable. That's what's given to us under Graham versus Connor. Get out there, do your job, learn your job. Be a little bit outside of your comfort zone. As long as what you do is within the constitutional rights and what is viewed as being objectively reasonable, you're going to be okay, both criminally and civilly. Take the time to learn this stuff. Read these cases. Reach out to us with questions. If you have ideas of how you want us to teach more of this via this YouTube or Teachable medium, if that's what's helping, do it. But it's on you as the officer to get outside of your comfort zone. This new officer did a phenomenal job. He articulated well, and though I'm sure he felt that he was beat up on the stand, he ultimately got a conviction and got somebody off the road that could have potentially hurt or killed somebody. On that note, looking forward to our next roll call. Again, happy holidays. Stay safe. Reach out to us if you have ideas for future videos. Like this video, subscribe for more. Happy holidays.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.